Good afternoon, ladies and gentlemen. My name is Adrian Ross from IT Governance. Hopefully we're all here for the same reason, which is to discuss appointing a data protection officer under the General Data Protection Regulation. This is a new law that's coming out of Europe, so hopefully we're all on the right webinar. Okay, now just before we commence here, just a couple of housekeeping things. My colleagues from marketing have said that a copy of the slides and a link to the webinar will be sent out tomorrow with an email. So just mention that to you and then quickly move on. We've got a number of slides here to get through in the time period, and then we'll have a question and answer session at the end for about 15-20 minutes. So that should take us up to about 4 o'clock UK time. So as I say, my name's Adrian Ross. I'm a governance, risk and compliance consultant with IT Governance. My background is in infrastructure services, business process re-engineering. Early in the 90s I was involved in what was then known as data warehousing and business intelligence. Through going to business school, I got involved in business architectures, and I also have a legal background, so one of my particular areas of interest is intellectual property and legal compliance, and through being involved in that some years ago with some of the major energy companies in the world, I then got to talking to IT governance, and from there developed. I originally did a couple of courses with IT Governance on 27001 lead implementer, lead auditor, and then developed my knowledge in data protection and information security. And also more recently have looked more closely at something called enterprise risk management. So within the world that we live in at IT Governance, we talk about information security, or we talk to clients about data protection, but also compliance and risk management, enterprise risk management. Okay, so very quickly, just a few words about IT Governance, who we are, what we do. We are a UK company that has been growing very quickly in relation to the work we do on governance, risk and compliance. We've recently opened an office in the Benelux countries, and more recently opened an office in the United States. We're currently about 250 people, and as you can see from this slide, I work within governance, risk and compliance function within the organisation. Some of my colleagues have backgrounds in service management, ITIL, COBIT, all these disciplines. And then the other side of the business, we look at cyber resilience, information security, and then across the bottom there we do lots of things in terms of consultancy and certification, security testing. We run a number of courses for training and qualifications. We have some toolkits that we have developed and are particularly relevant to small to medium enterprises. So we have a 27001 toolkit. We've also got GDPR toolkit, which is currently phase 1. Phase 2 is due for release now, and we've sold quite a lot of those and provided consultancy around those. And as you can see, my particular part of the business also does business continuity. At the bottom of that slide, we talk about all verticals, all sectors, and all organisational sizes. So we have everything from 1- and 2-man startup organisations to some of the very biggest companies, certainly in the United Kingdom and across Europe. We have very much got top tier customers in all sectors: banking, legal, some well-known worldwide manufacturing companies, certainly aerospace and defence. So we cover a lot of different sectors. So the agenda for today, ladies and gentlemen, is I'm going to give you an overview of the regulatory landscape. We're going to look at the territorial scope of this regulation. We're going to talk briefly about remedies, liabilities and penalties, talk a little bit about security of personal data, and then we'll get to the meat of the subject, which is appointing a data protection officer under the General Data Protection Regulation. Okay, so very quick slide on European law. the two main types of legal instrument that are relevant to what we are talking about are directives and regulations. Now, directives come out of Europe, and they tell each member state that here are a broad set of principles that we need to develop a law to meet these principles. And what happens under a directive is that each country then develops its own law to meet that directive. And when we had the last directive out of Europe that related to data protection was in 1995, as you can see there, 95/46/EC, and as a consequence of that we developed the UK Data Protection Act, which we brought out in 1998. Now, the GDPR is a different kind of law. It's not a directive, it's a regulation, and the theory with the regulation is that it brings harmonization across the 28 member states. But how it works in practice is that it's immediately applicable in each member state. Therefore, there's no requirement for each country to develop its own version of the data protection law. So there's nothing needs to go through the national parliaments. And as I say, the GDPR is a regulation. I think I said just a few seconds ago, it's supposed to harmonize the laws across Europe. However, the GDPR has over 40 derogations included, where each member state can vary the law or the regulation to suit its own particular set of circumstances. One particular example would be the age of a child, where each member state can vary between the age of 13 and 16. So there are a number of areas where there will be variation, and then of course this then raises the question, well, how harmonized is it? Well, you know, it's more harmonized than it would be under the directive or as it currently is, because what we have in the European Union at the moment is effectively 28 different data protection acts. And the challenge for organizations is that in the countries that they operate, they have to be aware of the different laws, and they can either do that by having the expertise in-house, or they can buy that in from international law firms, but either way that's quite expensive. So hopefully that just sets out the ground of the differences between these two, directives and regulation. But GDPR is a regulation, the intention is harmonization, although there is still going to be some variances between the different countries. Okay, so there are the key dates on this slide in relation to the adoption of the regulation, and as we can see there's a number of steps that has to be gone through before it becomes law. But the key point from this particular slide is that it becomes law on the 25th of May 2018, so we've literally got probably about 14 months now before this comes into force, and organizations are busying themselves trying to get ready for this date. Okay, so who does it apply to? Well, it applies to something that in the regulation called natural person. Well, a natural person is quite simply a living individual, a human being, as opposed to a corporate person like a company or a trust or a charity or something like that. So it applies to living individuals, and those living individuals or natural persons have rights associated with the protection of their data, protection in relation to processing of personal data, but also the unrestricted movement of personal data within the European Union. Now, those of us who've lived in Europe for some time will be familiar with the concept of freedom of movement of workers, and unrestricted movement of personal data means that data can follow us, you know, the natural persons throughout the European Union wherever we go. Now, what's in material scope is personal data that's processed wholly or partly by automated means, and what automated means in the context of this regulation is data that's processed by computers. And then that second line there, that's the line that refers to or sets out that also paper-based records are within scope of this regulation if they are part of a filing system. So if they're indexed paper records, they're in scope. If they're paper records that are not indexed in any way where you could identify a natural person, they're out of scope. So those two lines there represent electronic records and paper-based records. Regulation applies to controllers and processors in the EU irrespective of where the processing takes place. So if the controller or processor are in the European Union but the processing is taking place in India, for instance, that is within scope, and also applies to controllers who are not in the EU, where processing is in the EU. So the long and the short of that is, it doesn't matter where the controller or the processor reside, where they're established, if you like. If the processing relates to data about natural persons who are part of the European Union, then they are in scope. Okay, so natural persons have a number of rights. And to begin with, they have a judicial remedy where their rights have been infringed as a result of processing of personal data. Now, typically we will think of this as where their rights have been breached. So there's been a data breach, and we'll talk about those in a moment. But wherever those rights have been breached, they have a judicial remedy. Now, they can either bring an action in the court of the member state where the controller or processor has an establishment, or where the data subject habitually resides. They can also bring it in where they work or where the infringement takes place. So there's a number of areas they can bring the action. Any person who suffered material or non-material damage has a right to receive compensation. Now, this is quite a difficult one because historically in data protection law it is difficult to quantify what material damage is. So if my particular personal information gets breached, so for instance my sexual orientation or my race or ethnicity, it's very difficult to put a number on, you know, the damage, the material damage that has happened. However, the courts more recently have started to make awards for non-material damage and significant numbers, significant awards. And non-material is things like hurt feelings and certainly anything like that. Controller involved in processing is only liable for the damage caused by the processing. Well, there's a common assumption that we have very strict and clear lines between controllers and processors, and it's a one-to-one relationship between those two organizations. But in fact, you can be a controller who does processing too. So where damage is caused, the controller causes is involved in processing, and the damage is caused, it's only for the processing part, if that is the part that's breached. If the breach is attributable to the controller, then the controller on their own can be held liable. Now, in terms of administrative fines, this is something new within the regulation. We haven't had that before in Europe. It is intended that the fines will be effective, proportionate and dissuasive, and that is a set of words that means that organizations should take these fines seriously. Yeah, they're intended to have an effect. They will be proportionate to whatever has happened, and they will be intended to dissuade other organizations from doing the same thing. Okay, now these fines will take into account something called technical and organizational measures that have been implemented by either the controller or the processor, in fact both organizations. And technical and organizational measures are things like security controls where the data has been encrypted, whether it's been pseudonymized, or it's a technique called data minimization where we're narrowing down the data that we're using as part of the process that we're undertaking. Now, there's two tiers of fines here. There's 10 million euros or up to 2% of the worldwide annual turnover of the organization in the preceding financial year, or there is 4% annual turnover in the preceding financial year. Now, the rationale behind these is the articles within the regulation are split into these two tiers. The 4% tier takes account of things like the core data protection principles, which are the foundations of data protection law, but also things like rights of data subjects or natural persons, the security of data, everything like that, or lawfulness of processing is all in the 4% area, whereas the 2% I would say are more targeted at the operational elements of the regulation. So it's either 10 million euros or 20 million euros depending on which particular articles have been breached, and as I say 2 or 4% the worldwide annual turnover in the preceding financial year, which of course is a published figure. So it's not profit, it's turnover, and it's preceding financial year, so we know what that number is. Organisations will either have published that in their accounts, or they will have published it as part of their annual report for publicly listed companies. So that's how the regulation looks at fines. Okay, so moving swiftly on, we'll look at data breaches in the UK. Well, in January to March 2016, we're using 2016 data here because we've not yet gone through March 2017, so we don't have this period for this year. But in this period last year there was 448 cases within the United Kingdom, data breaches, and these are the ones that were reported and were acted upon. As you can see, a large proportion of them are in the health sector. Well, in the health sector in the United Kingdom we have mandatory breach reporting, but also the health sector has large amounts of sensitive data. Then you can see it's things like local government. Well, local government has a very diverse set of sensitive data. Homeless people, vulnerable people, relating to homeless, various groups within society. There's a very diverse set of data in local government. And then you can see the other disciplines within those data breaches, but quite significant number of data breaches in the UK. Okay, if we look at cyber breaches, well, if we look at those, you can see that across all organisations, whether a small end of the scale or very large firms, they are actually experiencing quite a high percentage of cyber breaches. Yeah, when we look at the costs associated with those, the average for large organisations is £50,000, but the highest can be up to £3 million. And in fact, we've had organisations in the United Kingdom who have had breaches and who have ended up making provisions in their accounts to repair the damage of tens of millions, actually. So those figures relate to, the majority of cyber breaches in the UK, but also I can think of one particular organisation in the telecom sector who ended up making almost £40 million provision in their accounts to do with a cyber breach. Okay. Okay, well, when we look at types of breach occurrence, we can see that clearly the biggest type of breach is to do with viruses, spyware or malware, 68% there, and then quickly followed up by other organisations, making impersonations in emails or online. So that seems to be coming to the fore now within certainly the sort of UK, and that's an Ipsos Mori cybersecurity breaches study. So as you can see from those figures there are a number of areas that breach occurrence happens. Even down to the bottom there, software being damaged or stolen, or breaches on social media now becoming more prevalent as organisations use social media for business purposes. Okay, so let's talk a little bit about the definition of a personal breach. Well, there is one within the GDPR, and personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. So that's quite a broad description there, or definition of what constitutes a data breach, and it's a bit like the definition within the regulation of processing, which is very, very broad, but so you can see from the words there that you don't actually have to physically have the data, if somebody's getting access to it, that constitutes a breach as well. Okay, so we're now getting to the sort of meat of this webinar, and we're talking about data protection officers. Now, Article 37 of the regulation lays out quite clearly that there are 3 situations in which a data protection officer must be appointed. Yeah, so this is the mandatory appointment of a data protection officer. And firstly, it's where the processing is carried out by a public body, public authority or public body. And typically within the United Kingdom, we think of local government as being a public authority, but also it covers anybody that represents the public. So we'll talk about that a bit more on the following slides. And then secondly, where the organisation's core activities require regular and systematic monitoring of data subjects on a large scale. Well, there's a couple of key words in there. There's core activities. What are those? Regular and systematic. What are those, and what does large scale mean? Well, we're going to cover those in a couple of slides. And then finally, where the core activities of the organisation involve large-scale processing of sensitive personal data or data relating to criminal convictions or offences. Okay, so we'll talk a little bit in the next few slides about large-scale processing. Sensitive data is a subset of data within personal data. Personal data has a very wide definition within the regulation and covers everything from our names to telephone numbers, address, any piece of information that can point to us as an individual is personal data. Sensitive personal data tends to, or more specifically, covers things like health, biometric or genetic data, anything that's in there, anything or things or data that would give away my race, ethnicity, philosophy, political opinions, sexual orientation, anything like that is classified as sensitive data. Okay, now whether we choose to appoint a data protection officer in one of these mandatory conditions or whether we want to do it voluntarily, the status is the same within the organisation. So I mean, when you look at these 3 mandatory scenarios, you can say, well, there's lots of organisation outside of that, and that is correct. So we think that a lot of organisations will choose to appoint a data protection officer voluntarily, and when they do that, the application of the regulation on the controller or the processor and the protection that the data protection officer has is exactly the same. So there's no difference whether it's voluntarily or mandatory. Okay, so let's look a little bit closer at public authority or body. As I said on the previous slide, it usually means national, regional or local authorities, local government in the United Kingdom, but it can also mean other public bodies. So it can be transport services, it can be water and energy supply, it can be road infrastructure, public service broadcasting would, the one that immediately springs to mind is our own BBC. Any authority or body that's involved in public housing. Well, a lot of our housing in the United Kingdom is provided by local authorities, but also we have lots of other housing trusts who provide housing for the public as well. So these will fall within the scope of this. And disciplinary bodies for regulated professions. So we have, for instance, last week we were running a course in Edinburgh, and one of the attendees was from the regulatory body in Scotland that looked after accountants as a regulated profession. So they will be within this particular mandatory appointment. An exception to this is the courts acting in their judicial capacity, but also there is something called the Article 29 Working Party. Now, the Article 29 Working Party is a representative from each country in the European Union, and also there is someone from the European Commission on that party as well, and they recommend that private organisations carrying out public tasks or exercising public authority designate a DPO as well. So there's a lot of, it's now broadened, and this particular information comes from a guidance paper on data protection officers that has now come out of Europe. There's a number of these guidance papers now appearing and clarifying what is meant by certain things in the regulation. So let's talk about core activities. Okay, so core activities are the key operations necessary for a controller or processor to achieve their goals. Now, core activities do not exclude processing. That's an inextricable part of the controller or processor activities. But also there are other activities that are ancillary to the functions of a business. So let me try and explain that a little bit for you. Core activities of a hospital would be patient care, and the ancillary activities to that would be things like human resources and IT. Okay, so let's look a little bit closer at regular and systematic monitoring. Well, again, this is one of these definitions that's not defined in the General Data Protection Regulation, but the Article 29 Working Party interprets regular as meaning one of the following: it's ongoing or occurring at particular intervals for a particular period, recurring at or repeated at fixed times, or constantly or periodically taking place. So that's regular. When we look at systematic, we're talking about occurring according to a system, so it's pre-programmed, it's pre-arranged, organised or methodical, taking place as part of a general plan for data collection, carried out as part of a strategy. So systematic, for those of us who've been in the industry for a while, the obvious words are batch processing, month end, all this kind of good stuff, or it's being run periodically to meet statutory obligations. Anything like that falls within that definition of systematic. Okay, a regular question that comes up for us in IT governance: well, what do we mean by monitoring? Well, it includes all forms of tracking and profiling on the internet, including for the purposes of behavioural advertising. I know from personal experience working with IT governance on the consultancy side that we have some organisations now in Europe that track people purely by their behaviour, and then seek to advertise based on that behavioural profile. So that constitutes monitoring. It's not restricted to the online environment, and online tracking should only be considered one example of monitoring the behaviour of data subjects. So I guess what we're saying there is it also includes things like geolocation data. Yeah, when people are moving around in London, we have these Oyster cards that people use to on the transport system. Well, that would be another particular way of monitoring if we were looking at that data to monitor behaviour of data subjects. Okay, large scale, again, not defined in the GDPR, and this was one of the derogations that we talked about. This could vary from country to country, but the following Working Party 29 recommends the following factors. Number of data subjects concerned. Well, that's a very subjective measure because you could have a small number of data subjects with highly sensitive data, or a large number of data subjects with just personal information, just personal data. And the sort of parameters they talk about applying is specific number or a proportion of the relevant population, volume of data or range of data items being processed, the duration or permanence of the data processing activity, geographical extent of the processing activity. So all these things would be taken into account if we're considering whether or not we're doing large-scale processing. So here's some good examples here. The Processing of patient data in the regular course of a business by a hospital, well, I mentioned that earlier, and obviously attached to that we will have a number of ancillary services such as HR, transport, IT, whatever. Processing of travel data of individuals using a city's public transport system. Well, that was exactly the example I gave just a slide ago when I talked about our Oyster cards that we have in the United Kingdom, where people, I don't use one myself, but I think the way they work is you buy credits online and then you don't have to buy a ticket every day, and you just swipe it every time you go in and out the underground. So processing of real-time geolocation data of an international fast food chain for statistical purposes by a processor that specialises in providing, well, this would constitute large-scale processing. Insurance companies or banks, yeah, that would be another example. Processing of personal data for behavioural advertising by a search engine. Well, we all know who the search engines are. Processing of data, content, traffic, location by telephone or internet service provider. We have some customers within IT governance who do exactly that. And this gather loads of information about traffic and location and all that type of information. Okay, so Article 37 talks about the designation of a data protection officer. Now it applies to both controllers and processors, so we shouldn't think that this only is applicable to controllers because they're the kind of the one in charge, if you like. It applies to both organisations, and in fact we can have some very big processors in the world, and certainly when we talk about cloud providers and the fact that they are, you know, normally classed as processors, some of the cloud providers in the world are extremely big organisations. There is designation on some mandatory criteria that we talked about earlier, but also that it's good practice, and each organisation will have to make its own evaluation about the need to appoint a data protection officer. Working Party 29 recommends that processors DPO oversees its controller activities, and this is particularly related to where we have hybrids. So the organisation is either in the main a processor but does some controlling activities, or is a controller in the main but does some processing activities as part of its own processes. So DPO has to oversee both. A group of undertakings can appoint a single data protection officer provided that person is easily accessible across the group. Yeah, so if you've got a group, and in fact that is just something worth saying there as well. Any fines that are issued in relation to this particular regulations are applied to the group. So if we have 9 companies in the group and they're all compliant, and then the 10th one breaches, the fine is applied against the 10, not the one that has made the breach. So therefore they've been quite explicit in this regulation to say that where it's a group undertaking, the DPO must be accessible by all parts of the group. Okay, accessible by data subjects and supervisory authorities, but also internally. Well, the data protection officer is the fulcrum, or the conduit, if you like, between data subjects, supervisory authorities, internally, but also particularly in relation to when the breach has occurred. Communication must take place in a language used by the relevant parties. Now what they're saying there is that if the particular language is, say for instance, French, any communication between the relevant parties has to take place in that mother tongue. Yeah, so if the controller and processor are in the United Kingdom, the language is English, but in other countries, you know, obviously they have different languages, and where you have a controller and processor operating across geographical boundaries, you've got more than one language, and the communication should be in more than one language. May be appointed for several public authorities depending on the structure and size. Well, we have public authorities in the United Kingdom who are actually quite small, and they can share this resource amongst themselves. Data protection officer can represent categories of controllers and processors. Well, if we have something like small to medium enterprises in the manufacturing sector, well, they can group together and share a data protection officer across that sector. Okay. The data protection officer will be designated on the basis of professional qualities and knowledge of data protection law, but it doesn't have to be legally qualified. Well, one of the things that we talk about on our GDPR foundation course and then our practitioner course is the data protection officer now has to have quite a wide range of skills, data protection law being one of them. Probably risk frameworks, probably has to be familiar with IT and technology, business processes. There's a whole bunch of skills that he has to have. Data protection, he may fulfill the role as part of a service contract. So what that means is you can buy it in as a service if the organisation doesn't feel that it warrants having a full-time data protection officer. It can buy in those skills by a contractor. The controller or processor must publish the DPO's contact details and they must notify the supervisory authority. So that's what comes back to, it says at the top there, Article 37 in the designation, we have to publish the data protection officer's contact details, how the data subject can get in contact with them, but also the supervisory authority. Okay, so 38 talks about the position of the data protection officer, and organisations have to ensure that there's proper and timely involvement of the data protection officer. Now what that means is you get them involved in projects at the very beginning, not at the end when everything's been done. They must provide the necessary resources. Well, there is a definition within the regulation, but it covers everything from money, time, assets, training, everything. There's a legal obligation on the organisation to provide anything that the data protection officer needs to fulfil that role. They have a large degree of independence within the organisation, so they are free from influence by anyone within the organisation, and it's a protected role. So if the data protection officer has a difference of opinion with, for instance, management, particularly within the service delivery part of the organisation, or in fact the directors, that role is protected by law. They cannot be fired for disagreeing with anybody within the organisation. They should have direct access to highest management, and then this is encapsulated in something called board awareness of data protection law. So there should be a direct link between the data protection officer and someone on the board of directors. Data subjects must at all times have clear access to the data protection officer. That goes back to the previous slide where we said they have to be designated and be able to be contacted. They are bound in by confidentiality in accordance with EU or member state law. What that means is confidentiality varies from between the different member countries in the European Union, and in some countries it's taken very seriously, and the data protection officer is bound by it. There should be no conflict of interest arising from additional tasks or duties, and what we mean by that is this is a role that does not sit within the service delivery part of an organisation, because immediately there is a conflict in terms of what's delivered and timescales and all. This is a more strategic role, so an assurance type role. Yeah. Involvement of the DPO itself will facilitate compliance by the GDPR. This comes from one of the guidance papers from Article the Working Party 29. And what they are saying there is that organisations will need to be able to demonstrate the involvement of the data protection officer, and that in itself will facilitate compliance with the regulation. But also involvement of the data protection officer will ensure the adoption of something called data protection by design, or the approach to that. And what that is about is putting the rights of the data subject first, and when any new project involving technology or systems or integration projects is undertaken. I mean, we've seen that within our consultancy division at IT Governance, where organisations sometimes do it, and usually they do it as the last thing in the project cycle. And what data protection by design is about is putting the data subject rights first to begin with. Okay, so there's the tasks of the data protection officer: inform and advise, monitor compliance, provide advice with regard to data protection impact assessments. Well, data protection impact assessment is used whenever there's a new technology or new system going live within an organisation. And in fact, I had this very thing yesterday at a client site where they've used the system for years, but the system is due to be not supported in the next couple of years, so they have to find a replacement. And all of this organisation's data is contained within the current system. It's a case management system, so they're having to replace it, and this is where you would do a data protection impact assessment, which looks at the risks involved in going live with new technologies and systems. To monitor performance of DPIAs, cooperate with supervisory authorities, have due regard to risks associated with process. So the data protection officer is required to do risk assessments, be familiar with risk frameworks, and to focus their efforts on issues that present higher data protection risks. Now, this doesn't mean they ignore the lower data protection risks, but they should be rating all the risks and focusing their efforts on the major ones at least. Data protection impact assessment, and the controller has to seek the advice of the data protection officer when carrying out a DPA, when using new technologies and taking into account nature, scope, content and purpose of the processing, where there's a high risk to the rights and freedoms of the natural person. Well, high risk to rights and freedoms isn't defined in the regulation, but we can assume that it covers things like where sensitive data in particular is being utilised. Now, a single DPIA is particularly required where we've got these conditions here: automated processing, as we said earlier, is by computer, any form of profiling, or anything that creates legal effects for natural persons, so where they have to do something, where they have to stop doing something, and where that processing is on a large scale, particularly related to criminal convictions, anything like that. A single DPA may address a set of similar processing operations, so you can have one DPIA that looks at different things that are going on within the different systems that are going live at the same time. Yeah, and a DPIA, well, this is what it should contain as a minimum: systematic description of the purpose of the processing, legitimate interest pursued by the controller, and assessment of the necessity and proportionality of the process. So why are we doing this, and how big is it? What is the proportion? When we look at the proportionality, how big a deal is this? The next line there, I think, is quite important. That's the one that sets out we have to do risk assessments. Then we do have to look at how we've treated those risks, whether we're adhering to any codes of conduct, whether there's anything relating to any consultation with the data subjects, has that been undertaken, and particularly any processing that changes the risk profile of the organisation. There's something called prior consultation, and what that means is, particularly where there is a high risk to the rights and freedoms of data subject, we have to do a DPIA, and we have to consult the supervisory authority with regard to that DPIA, and the data protection officer is the man who will, or the person that will do that. He will be the conduit in terms of doing that. We have to provide, the supervisory authority will provide advice back to the controller on whether or not they think the data protection impact assessment covers enough, is broad enough in scope, has done its risk assessments correctly, and done enough to mitigate the risks. So there are information going back and forward between these two organizations. Okay, so this is an additional check, if you like, in addition to the data protection impact assessment, where we have to go to the supervisory authority in certain circumstances and say, this is our plan, and they say, well, we like your plan and it meets all the criteria, or they may say, well, actually you haven't done enough of a risk assessment, or you haven't mitigated the risks appropriately. So the data protection officer is the person that does this. So it's a strategic role that develops, coordinates and manages the privacy strategy within the organisations. It ensures that operations and business practices adhere to the applicable privacy laws, because remember I said at the start they may vary slightly between the different countries, and ensures that privacy considerations and processes are incorporated into the practices of the organisation. The question is then, should there be a specific board member with accountability for the privacy strategy? Well, yes, there should be someone on the board who is overseeing or is at least aware of what is going on in terms of privacy within the organisation. What relationship should have the DPO with legal advisors? Well, he's going to have to be familiar with data protection law without being legally qualified, but there will be situations where he will have to get legal opinion in certain circumstances. So the reality of the role looks something like this. Legal knowledge of data protection regulations is necessary but not enough in itself. They must also be able to articulate privacy by design to the delivery functions of the organisation, has to have information security knowledge, so we've got a CINA there from ISO 27001 world, good understanding of risk management and risk assessments, to be able to coordinate and advise on data breaches and notification with supervisory authorities, be able to handle a cybersecurity incident response framework, carry out and interpret internal audits against the compliance requirements, be familiar with any particular industry codes of conduct, have a good understanding of compliance standards, data marks, lead the cooperation with the supervisory authority, and it has to have good communication skills. Okay, so in terms of cybersecurity, getting back to, because let's remember that data breaches can either go from inside the organisation out or can be from the outside in. The GDPR has a requirement that each organisation implements appropriate technical and organisational measures. Yeah. Now, for controllers, they must have data protection policies, adoption of codes of conduct, adoption of standards. So ISO and BSI are both developing GDPR standards. We've got 27001 and also there's 10,012, I think it is, that looks at data protection, BSI 10,012. And this provides assurance to the board that data security is being managed in accordance with the regulation. So what we're trying to do is cover all the information assets, all the information security, and protect us against all the threats. Okay, just very brief bit about IT governance. Just to say that we run a number of courses, foundation practitioner. We have various publications now relating to GDPR, implementation guides, various other things. We have toolkits, we do consultancy and support, and actually my marketing colleagues have asked me to remind or mention that I think it's week after next we have a course running in Dublin, so there are still places available for those of you who are interested. Okay, so we've run a little bit over time, 4 minutes over time, but if we have any questions, we can take questions now. So if you can just, if anybody's got any questions, if you can just send them into the chat line. Okay, we've got one question here. When can we? How does an organisation know when it should appoint? When it should appoint a data protection officer? Right. Well, this will vary. Originally, when they brought the regulation out, they came up with this idea that any organisation 250 employees or more should have a data protection officer, but then they dropped that requirement. There is still the 250 number in the regulation, and it relates to the level of reporting that the controller has to undertake. Okay, so really it comes down to each and every organisation to make its own call. There are the mandatory requirements or situations where a data protection officer has to be appointed, but clearly it will be for each organisation to effectively do a risk assessment on itself to see whether it should appoint a data protection officer. Now there's another question here from Chris. If files are indexed, they are in scope. Yep, so basically, can you elaborate this with customer name was left on the desk because it's not indexed? Well, something that's left on a desk on its own is not indexed, doesn't constitute an index system, but if that information was then out into the wide world, i.e. a breach, well, that would be a different situation. So therefore we would be having a discussion with the supervisory authority. Is it acceptable to appoint a data protection officer who will also be your information security manager, from Stephen? Remember I said earlier there was also something that there has to be no conflict, and this is quite a relevant question actually, because people say, well, can we have information security function do this? Well, of course you can. It's just that information security approaches data protection. It's not the same as data protection. So as long as there was no conflict, I think specifically within the regulation, Stephen, they're talking about where the data protection officer might be within a delivery function of the organisation. I mean, clearly you can't be delivering projects and also provide independent assurance at the same time. Okay. Can the DPO be a job share? As long as it doesn't conflict with, as long as he can apply himself to the data protection issues, you can't go back and then say we didn't have enough time to do it. Are universities public authorities? Well, that's a good question. What I would say is that we're seeing a lot of universities taking a very close look at this at the moment. How would you define a large-scale process? How is large likely to be quantified by Matthew? Well, I think what's going to happen, Matthew, we've already started to get some guidance come out of Europe in relation to things like core activities. We've had some, I would say high-level guidance on the slides there about large-scale data processing. But clearly, I would say, well, we had a course that we ran last year where a charity had attended one of the courses, and they were quite open that they'd actually had a data breach, and they had only breached 150 records, but it was 150 sensitive records. And that is exactly the point I'd like to make, is that volume is no guide to seriousness, if you like. So I think there's further guidance going to come out about this. And also, don't forget that over a period of time there will be development of sort of fines under the GDPR, so we'll start to see how those work. And one of the things that the European Union is very keen is for the application of consistency across the European Union. Okay, so if we have a fine for, I don't know, say 10,000 sensitive records in the UK, there will be one level of fine, and then if something very similar happens in France, well, it's not going to be wholly different. They're looking to have some measure of consistency across the European Union. Right, so just reading another question here. If you provide infrastructure services including data backup, but no access to or knowledge of the data contained, are you still considered it, and how would you know if it's large scale or personal? Well, that's from Barry. Well, data backup would constitute processing, yeah, very definitely, because that falls within the definition of processing in the regulation. How would you know it's large scale or personal? Well, personal information is anything that's in there whereby you can identify a natural person of the European Union. Are retrospective DPIs required for existing processes that have been in place for some time? That's from Martin. I would say no. But actually that raises something along the lines of consent. Consent is one of the fundamental changes within the regulation, so wherever we have had information being gathered or processes being undertaken where organisations are assuming consent, that no longer works. So there's not going to be any more pre-tick boxes. So our consents are going to have to be looked at. So anything that changes after the 25th of May, and this is getting back to your question, Martin, if for instance we have got valid consent at the moment and then the business introduces another process because it wants to add value to its customers, well, we then have to go and get consent again to that additional process. So this is where organisations will have to look at things going forward, but retrospective DPIs, no. What would be the best background of a DPO, IT, security or law? Well, I think, you know, we met someone the other week who probably had a good mix, and this particular person was a qualified lawyer, had studied law, but also was a practitioner in information security, but also a risk practitioner as well. And this particular chap had, you know, excellent communication skills and you know, various other things. Had a business background too. So all of those things together made them an ideal candidate. So, you know, but that's very unusual indeed. Companies with less than 250 employees require a DPO. That's from Antonio. Potentially, yes. I mean, because the number of employees is absolutely no, you know, nothing you can apply to the sensitive data, the amount of sensitive data that's around, or volumes. So I think that's possibly why they took the 250 out there in relation to the DPO, because you know, the number of employees in an organisation bears no relation to the sensitivity or the risk that is adopted. Is it to appoint the IT manager? Is it okay to appoint the IT manager as a DPO? Well, the obvious answer there, Timothy, is it's okay as long as the IT manager doesn't have responsibility for service delivery, project delivery, because that puts them in conflict. Okay, so I'm just flicking through these questions now. Okay, supervisory authorities. How do you decide which is the right one? Supervisory authority that you will adopt would normally be the one where the controller or processor is established. And establishment is a word in European law that usually means, it's a legal word that usually means where they have the head office or where they have the data center. Or if you don't have either of those, it's where the processing or profiling is taking place. That will determine where which supervisory authority is applicable. Okay, well folks, that's us come up to 4 o'clock now. I'll just do one final question there from Antonio. Is there a list of European supervisory authorities? There is a list actually, and I got it from the European website. Maybe if you email me, Antonio, I can find that again for you. But there is a list. Part of the issue is that in some countries they have more than one supervisory authority. In the United Kingdom we just have one. In Germany they have over 40. So hopefully folks that's answered your questions. I think I've got our email address there somewhere, so if anybody's got a particular issue you can always email me and I'll get back to you eventually. But thank you very much for your time today on behalf of IT Governance. And as I say, I just said there's a course going on in Dublin. I think it's week after next, and there are discounts available for people who are interested. Okay, so thank you very much folks. Thank you, goodbye.